Hello, I'm Gabriella Samaniego, and I'm very excited today to be presenting about wrongful convictions, explaining false pleas. I was fortunate enough to be the recipient of the first year research experience award at the University of Oregon, allowing me to conduct this important research. And I also wanted to give a special thanks to Dr. Erin Beck for being my faculty mentor throughout this project and helping guide me. So, first off, what is a wrongful conviction? The Innocence Project defines a wrongful conviction as occurring when a factually innocent person is convicted of a crime they did not commit. They describe it as a symptom of a broken criminal legal system that must be fixed. My desired outcome from this research was to be more knowledgeable on how we can combat wrongful convictions in the justice system and work towards a more just and equal system overall. It's important to note that there's a clear disproportionate effect of wrongful convictions for people of color. Of the total 3,604 exoneration cases in the National Registry of Exonerations, 2,430 of the cases have an exoneree who is Black, Hispanic, Native American, or Asian. And this accounts for 67% of the cases recorded in the database. Alarmingly, 53% of the cases in the database were cases with Black exonerees. Yet the Black population only accounts for 13.6 of the United States total population, according to the census for 2020. So, in analyzing the amount of overrepresentation in the National Registry for people of color, it becomes evident that these populations are at great risk or threat of wrongful convictions. In conducting a secondary literature review, my question was what makes these populations more vulnerable? However, I quickly came to realize that there are numerous factors that go into wrongful convictions. There's no one explanation for the large racial disparity. Nevertheless, it is clear that a racial bias and discrimination takes form in multiple ways throughout the legal process, making people of color more vulnerable to wrongful convictions. After this discovery, I decided to hone in on one specific process in convictions, which was plea bargaining. So, for me personally, when I envision the judicial process, I mostly think of lengthy trials leading to conviction. Surprisingly to me, trials are not as common and make up a very small portion of convictions. Plea deals actually account for a larger amount of convictions, accounting for an estimated 95% of felony convictions. This is due to the overcrowded criminal justice system in which holding a trial for every defendant would take too much time and resources. Plea deals allow for convictions while saving money, time, and resources. In a plea deal, a defendant pleads guilty and waives their right to a jury trial in exchange for a lesser sentence or charge. However, I was mostly concerned with false guilty pleas, which is when someone accepts a plea offer from the prosecutor for a crime that they did not commit. This is slightly different than a false confession when someone admits to a crime they didn't commit to law enforcement. A plea deal, there's different factors that play into that, even though they are very similar. My methodology for this project is I proposed two questions. So, first, what factors led to a false plea deal? And how do these factors contribute to the stronger likelihood of people of color pleading guilty despite their innocence? So, I first started with a literature review. I looked at various data sets, podcasts, interviews, academic sources. And then I did a meta-analysis of what I've learned from those literature reviews and looking at different cases and looking for those different factors talked about in various literature within those cases. From this, I determined what I believe to be the three most significant factors. The first being misconduct in interrogation and investigation, the second being inadequate legal defense and advisory, and the third being incentive plea deals. One large factor that was seen repeatedly was misconduct in interrogation and investigation. I narrowed the types of misconduct I observed into three categories: the environment, the feeding of false information, and the holding of suspects. Looking at the environment, forensic interviewer David Thompson described how the physical environment of an interrogation room contributes to the likeliness of a suspect feeling trapped and resorting to a false plea. Thompson attributes this feeling to the layout of the room. So while a suspect may be free to leave, and while a suspect may not be in custody and is legally free to leave, The way most interrogation rooms are organized conveys the opposite, leaving suspects feeling trapped and uncomfortable. These environments are formed by situations such as an officer standing in the path to the door or standing over the seated suspect, claiming the authority in the room. Thompson trains officers in a non-confrontational interrogation model and proposes that if the true purpose of interrogation is to create a comfortable space to share the truth, the surrounding environment should reflect that. Secondly, the feeding of false information is a common tactic used in investigations. Despite common belief, police officers are legally allowed to lie to suspects during interrogation, so even so much as generate fictional evidence and fabricate existing evidence. During interrogation, officers will often make a suspect feel as if they've already been proven to be guilty by describing fictional, incriminating eyewitness accounts, DNA evidence, photos, and various other pieces of evidence. With the belief that they're going to be found guilty no matter the truth, due to the solid incriminating evidence described, suspects are more inclined to agree to a plea deal despite their innocence. Lastly, interrogations take advantage of the strain put on suspects when they have been in holding for prolonged periods of time. According to a study titled Temporal Discounting, published in the Law and Human Behavior Journal, on average, people who falsely confess were interrogated for up to 16 hours before confessing. Research also suggests that the reliability of a confession is greatly reduced after a prolonged interrogation, not to mention that when suspects are arrested and in holding for days on end before being convicted of anything, innocent suspects are focused on how they can get home, leading to some accepting a plea deal that brings the option of bail into play. Martell Williams, who's just 15 years old, is a prime example of these tactics in action and persuading an innocent person into a false confession. In 2022, Williams was pulled out of class and arrested for a robbery and shooting at a Dollar Tree. Without a lawyer present, Williams falsely confessed to the crime after being coerced during interrogation for multiple hours. As you can tell from the photos of the interrogation room that Williams was held in, it fits Thompson's description of being cold and unwelcoming to open conversation. The physical environment was specifically cold. Williams requested a jacket multiple times during interrogation, which that request was denied. There's an uncomfortable inequality in the room due to the clear power dynamic of the detectives versus Williams, reinforcing by the age and authority difference between the two. These factors contribute to the overall climate of the conversation and adds to Williams' desire to go home. Secondly, throughout the interrogation, we hear Detective Ains feeding Williams facts of the case as well as falsely reaffirming that Williams will get to go home if he confesses. At one point, Detective Ains says that he has seen, quote, people walk out of this building after shooting people because they explain the context of the situation. It continues to suggest that people walk free if the crime is in self-defense. By doing this, Ains is conveying to Williams that if he confesses that the crime took place in self-defense, he will be able to go home. Ains also told Williams that there was an overwhelming amount of evidence tying him to the crime when no such evidence had been discovered yet. This left Williams under the impression that he would be found guilty in a trial. Lastly, Williams was interrogated for hours on end while being bribed by officers with McDonald's. After being in holding for a prolonged time, along with the other factors of the climate of the interrogation and the feeding of false information, Williams falsely confessed to the crime and is one of the many victims of misconduct while in interrogation. Luckily for Williams, his alibi of playing in a basketball game was able to be corroborated by friends and family. The second factor I honed in on was inadequate legal defense and advisory. Public defenders are overloaded with cases leading to a number of defendants receiving inadequate legal defense. It is especially important to have a proper legal defense when negotiating plea deals because it helps you avoid blind plea deals or being coerced into a plea deal that doesn't have your best interest in mind. American Bar Association reported in January of 2022 that Oregon has only 31% of the needed number of contract attorneys to adequately represent all defendants. This also leaves people experiencing poverty more vulnerable because they cannot afford to pay for a private lawyer. And the last factor is incentive plea deals. Professor Lucian Durbin and Dr. Vanessa Edkins conducted a psychology study to explain the innocent defendant's dilemma during plea bargaining, which is when innocent people attempt to defend their innocence. The question posed was, when do the consequences of not taking a plea deal outweigh maintaining innocence? The study they conducted was with a random population of college students. The students were accused of cheating on a logic test being administered and later offered two choices: admitting to the offense and losing their compensation, or maintaining their innocence and facing a trial with the Academic Review Board, which, if lost, could include another plethora of possible consequences, such as taking an ethnic course, possibly being expelled, while also losing their compensation for the study. This situation effectively replicated the situation many innocent people face when they're offered a plea deal. Durbin and Dr. Edkins found that more than half of the participants falsely admitted guilt when faced with the two options of the plea bargaining. The possible consequences outweighed their desire to preserve their innocence, making plea deals more incentive. One case I analyzed that highlights these three significant factors is the exoneration of Marilyn Malero. On May 12th, 1922, two members of the Latin King street gang were killed. The following day, Marilyn Malero and Jackie Montez were arrested in connection to the murders. Malero's request for an attorney was denied, and she was continued to be questioned for 9 hours without representation. Malero was experiencing both prolonged holding and inadequate legal defense. In this case, no legal defense. The police lied to Malero, telling her that Jackie confessed and placed the blame already on Malero, feeding her false information. Detectives presented Malero with two choices. She could confess to one murder, or maintain her innocence and face charges for both of them. The possibility of the death penalty was also on the table, creating an incentive to plead guilty, um, by the consequences outweighing maintaining her innocence. Malero signed a prepared statement, and her attorney entered into a blind plea deal, which is a legal strategy where a defendant pleads guilty to a crime charges without a plea deal. So the sentencing is left to the judge in this case. Malero becomes the first woman in Illinois to be sentenced to death after this. But with help from the California Innocence Project, the Exoneration Project, and the Illinois Innocence Project, Malero was granted a clemency petition, which is where the governor agrees to reduce the sentence or ease the burden of a conviction, but does not overturn the conviction. In April 2020, Malero was released as a free woman after more than 26 years in prison for a crime she did not commit. So I ended up, at the end of my research, drafting 4 propositions that I think could help address these factors. The first, deploying a non-confrontational interrogation model like Thompson described. He has a wonderful example of this as the peace model. Number 2, more oversight over confession and plea deals from a non-biased party. So looking at what happened before this confession and plea deals that made the defendant want to take those options. And number 3, providing sufficient legal defense. So providing a public defender is not enough. There needs to be more sufficient legal defense that's effective. And number 4, removing incentives for convictions. So not basing promotions or raises for detectives or officers based off of their conviction rate, reducing that incentive to convict innocent people. For future research, I would want to look at how do these factors contribute to the stronger likelihood of people of color pleading guilty despite their innocence. Now that I've determined those 3 major factors, I would love to know more about digging deeper into what causes this racial disparity. Thank you so much for listening, and have a great rest of your day.